All right. Good evening, everyone, and thanks for coming out tonight. Special thanks to the Lincoln Douglas Society and to Cameron and Carter for organizing this event and for starting this society. It's great to be back in conversation with Christopher Mills again, and I'm delighted students are joining us this time. Christopher Mills is the founder of Sparrow Law, LLC. He was previously a partner at a national law firm and a constitutional law fellow at the Beckett Fund for Religious Liberty. He served as a law clerk to Justice Clarence Thomas on the United States Supreme Court during the October term of 2018. He also clerked for the Honorable David B. Santel, then Chief Judge of the U.S. Court of Appeals for the D.C. Circuit. Christopher most recently submitted several amicus briefs at the Supreme Court in United States versus Skrmetti, the landmark case on gender transition care for minors the court will decide this term. Chris is a 2009 graduate of Furman and a 2012 graduate of Harvard Law School. Let's give Chris for a warm Gamecock welcome. Joshua Strickland will be Mr. Mills' debate partner tonight. Joshua Strickland is a second-year law student at the University of South Carolina Joseph F. Rice School of Law. Joshua studied at Limestone University in Gaffney, South Carolina, graduating from the honors program with a BA in criminal justice in 2023. Joshua spent last summer as a law clerk for Callison, Ty, and Robinson, a civil litigation firm in Columbia, and as a research assistant for Professor Joseph Steiner. In addition to clerking for the South Carolina State Judiciary Committee, Joshua is a member of the Federalist Society, the Christian Legal Society, and serves on the editorial board of the South Carolina Law Review. Let's welcome Joshua. We're delighted to have you join the debate. All right. Okay, now to the proposition for tonight. First I want to clarify that the precise question before you all tonight is not whether the state can or should ban gender-affirming care for trans minors in general, but rather whether the state can and should do it in the way that Tennessee is doing it now. In other words, is the Tennessee law constitutional? Is it good policy? As Alex and I will argue, the answer is both. The answer is no to both. It's unconstitutional and bad policy because it's irrational. The following two stories are going to begin to reveal why. First is the story of Avery. Avery is a 15-year-old whose birth sex was male. When he started puberty, he began to develop more breast tissue than his other male peers, a condition called gynecomastia that affects about 50% of cisgender men and boys and frequently comes on during puberty. Avery asked a doctor to help him reduce his excess breast tissue, not because the excess tissue is causing him any physical pain or poses any physical risk, but because it feminizes his body, doesn't align with how he wants to present himself. It's also a common source of bullying from his extended family and some of his friends. Under Tennessee's law, and others like it, Avery's doctor can prescribe hormones, estrogen suppressors specifically, that will alleviate the psychological harm he experiences from excess breast tissue. Avery's doctor consulted with Avery and Avery's parents, and they all agreed to move forward with the treatment. Now suppose we change Avery's birth sex to female. In other words, Avery is now a transgender boy instead of a cisgender boy. But everything else stays the same. Trans Avery develops excess breast tissue and wants to remove it for the same reasons that cisgender Avery does. He's getting bullied, it doesn't conform to how he wants to present himself, feminizes him. These laws ban the doctor from prescribing trans Avery the exact same hormone, the exact same risk, for the exact same reason. Even though Avery's doctor, Avery, and Avery's parents all agree that this is the best decision for Avery, Tennessee says it knows better. The same is true for other types of gender-related care. Each year, between 4,000 and 5,000 cisgender girls under 18 get breast augmentation surgery in order to align their body with their sense of self. But trans girls cannot, even though it's the same procedure, breast augmentation, for the same reason, gender affirmation. Cis girls with visible facial hair can take hormonal medication for the sole purpose of removing it. Trans girls can't. Same purpose, same medicine, same risk, same side effects. It's irrational to allow cis minors to receive the exact same treatment the state bans for trans minors, particularly in light of the fact that most of the minors who seek out this care are cisgender. The second story involves infant Claire and her parents. Claire is intersex and was born with ambiguous genitals. In other words, they don't resemble a typical penis or vagina. Claire's parents ask a doctor to perform surgery on Claire's genitals for the sole purpose of creating a typical-looking vagina, not for any other medical reason. Claire's genitals work just fine. She can urinate just fine. They don't cause her any physical harm or pose any physical risk. And yet the laws allow the doctor to perform this unnecessary genital surgery on Claire, putting her at risk of genital dysfunction, scarring, loss of sexual feeling, chronic pain, emotional distress, particularly due to its non-consensual nature. Even though these laws ban much less invasive and less risky treatments for trans minors, these laws do not ban these procedures. Indeed, they have an explicit carve-out in the statute allowing them. Permitting non-consensual and unnecessary surgeries on intersex infants' genitals while banning all gender transition care for minors is irrational. I ask you to keep these two stories in mind as Alex and I march through our legal and policy arguments, and we hope we will convince you to vote no on the motion. So first, I'm going to argue why these laws are unconstitutional, then Alex will tackle some related legal and policy points. Okay, so this law violates the Equal Protection Clause. Right? So first, to address a couple of points that my friends on the other side said. We agree that states can certainly regulate medicine, but within the confines of the Constitution, there are no special equal protection rules for medical treatment. Also, it is well established that intermediate scrutiny applies to sex discrimination, that the Constitution, Equal Protection Clause, covers sex discrimination. Right? To conclude otherwise would override decades of precedent back to the 1970s. The Supreme Court has never said anything close to that. Okay, so to be sure, not all regulations on gender-affirming care for minors are unconstitutional, but this law is. It violates principles of equal protection doctrine that are fundamental. Okay, so the first question here is what level of scrutiny applies? Right? And the Supreme Court has repeatedly said over and over that laws that treat people differently based on their birth sex trigger intermediate scrutiny, and this is exactly what these laws do. They treat people differently based on their birth sex. Most obviously, birth sex determines whether a minor can get access to a treatment. In Avery's example, Avery's birth sex is what determined whether he could get the hormones or not. If Avery's birth sex was male, he could get the estrogen suppressors. If Avery's birth sex was female, he couldn't. Moreover, these laws only ban treatments for the purpose of gender transition. In other words, to move the body out of line with minors' birth sex. But in order to know whether a treatment is for the purpose of gender transition, we have to know the birth sex. Mr. Mills argues that this is not a sex classification, that it's a purpose classification, right? So that cisgender Avery is using the hormones to treat a different condition, gynecomastia, than trans Avery is, gender transition, gender dysphoria. But this is just a linguistic trick to obscure a sex-based treatment, and linguistic tricks do not change the law. Right? The purpose is the same. The treatment is the same. It's the same hormone. The purpose is the same, to reduce breast size. And the reason that trans Avery and cis Avery want to reduce their breast shape is the same. Gender affirmation, not cancer treatment, not some other type of treatment. It's the same purpose. Okay. For puberty blockers, well, actually, I see the time. I'm going to move on to the application, and if I have time in rebuttal, I'll come back to the puberty blocker point. Because it doesn't matter whether intermediate scrutiny applies here, because this law fails rational basis or intermediate scrutiny. So here's why. On equal protection, we have a two-pronged test, right? So first we look at the state interest. Is the state interest legitimate, rational basis, or important, intermediate scrutiny? Second, we ask, how does the law relate to that interest? Does the law rationally relate to that interest? Does it substantially relate to that interest, intermediate or rational basis? So I'm going to march through the interests that the state purports that justify these laws, and I'm going to tell you why all of them fail either standard of review. Okay, so the first state interest Tennessee says, is that this law encourages minors to appreciate their sex. Right? So it doesn't want minors to move their bodies out of line with their birth sex. But this is not a legitimate, much less important governmental interest. Indeed, in the Scarametti case, Tennessee doesn't even defend this interest. A preference that people born female look and identify as women, and a preference that people born male look and identify as male is paradigmatic sex stereotyping. The state's not allowed to impose its ideological preferences about sex and gender onto its citizens, including on a rational basis. Moreover, this law isn't even rationally related to this interest. The law does not want all minors to appreciate their sex bodies exactly the way they were born. It does not want or need cisgender Avery to appreciate his naturally occurring breast tissue. It does not need Claire's parents to learn to appreciate her naturally ambiguous genitalia. The state only cares about minors appreciating their sex bodies when those bodies already conform to what the state thinks those bodies should look like. Another justification the state puts forth is that this law protects the health and welfare of minors by banning treatments with clear risks and uncertain benefits. Of course, protecting the health and welfare of minors is an important governmental interest, but this law is not doing that. As an initial matter, the premise of this interest, that these treatments' risk clearly outweigh their benefits, is not grounded in sound evidence. The state exaggerates the risk of these treatments, ignores that these risks can be mitigated, doesn't ban other treatments that are equally risky or even more risky than these treatments. Moreover, the Tennessee legislature did not consider the medical benefits associated with gender-affirming care. And that silence is striking, considering that every major medical organization to take a position on the issue, including the American Medical Association, the American Academy of Pediatrics, the American Psychological Association, all agree that these treatments are appropriate and necessary when they are clinically indicated. Of course, state legislatures are not bound to follow the views of the medical community uncritically, but here, Tennessee uncritically rejected the medical consensus without attempting to conduct its own weighing of the perceived risks and countervailing benefits. But even assuming we defer to the state on the medical evidence, even assuming its conclusion that the risks outweigh the benefits, this law still fails because it's not rationally related to the state's interest in protecting the health and welfare of minors. If these treatments are really as dangerous or uncertain as the state says they are, why does the law allow cisgender minors to receive the exact same treatments for the same reason? If trans Avery cannot take estrogen blockers to reduce his breast size because these drugs are too risky, cisgender Avery shouldn't be able to either. Not banning these treatments across the board undermines the state interest. And considering the fact that over 90% of minors who get these treatments are cisgender, this law is shockingly under-inclusive. The state also minds its interest when it explicitly exempts treatments that have high risks and no benefits, like the one at issue in Claire's story. Allowing a doctor to perform non-consensual genital surgery on baby Claire does not benefit Claire, but it comes with all sorts of risks. Very thirsty tonight. Additionally, one specific risk the state focuses on is the one related to regret. That minors are going to regret the decision to transition, and that therefore these blanket bans prevent the harms related to desistance or detransitioning. But these laws are not rationally related to this interest either. First, the regret concern only applies to treatments that are hard or impossible to reverse. If a treatment is easily reversible, we don't need to worry about regret. So this interest cannot support the parts of the law that ban puberty blockers and most hormonal treatments. Once someone stops taking puberty blockers, they go through puberty. Once someone stops taking cross-sex hormones, their endogenous hormones will take over. Second, if the state is really worried about regret from irreversible treatments, why does it allow non-consensual, unnecessary, and irreversible genital surgery on babies like Claire? Many intersex minors grow up and wish their parents had not chosen to have doctors perform that surgery on their genitals when they were infants. And why does the law allow cis minors to have treatments that have higher regret rates than those given to trans minors? For example, there's a 9% regret rate among cis girls and women who have breast augmentation surgeries. Why is the state not worried about regret here, where regret is more likely, significantly more likely, than with gender transition care? Moreover, the state acknowledges that, I'm running out of time, so let me wrap to the end. I'll save that for rebuttal. Okay. At bottom, these laws do not serve any legitimate interest. The state claims it's interested in protecting minors from risky or uncertain treatments, but then it bans these treatments only for trans minors, even though trans minors make a tiny percent of the people who get this care. So is the state really worried about the medical risks of this care, or is the state actually interested in enforcing its ideological preference that minors be cisgender, not transgender?